Hello and welcome to Competology Academy, and today we are going to discuss our next part of the Santhal Pargana Tenancy Act, and that is going to be for chapter 6 and chapter 7, right? So here today the Santhal Pargana Tenancy Act, and hereafter we will be left with only one part of the Santhal Pargana Tenancy Act, that will be of chapter 8 and chapter 9. So here the other videos which were discussed earlier to this video, that is those are related to chapter 1 to chapter that of 5, are in the playlist itself. So those who want to go through those videos can go to the channel and they will find it in the playlist, that is Santhal Pargana Tenancy Act 1949, the Jharkhand land related laws, right? So those who have not subscribed the channel and not pressed the bell icon till now can go on to channel, subscribe the channel and press the bell icon to get notified whenever we upload such videos or whenever we are applied for such kind of discussions. So let us start with this chapter 6, and here it says that the acquisition of land by the landlord for certain purposes. So here, like we all know that the government does the land acquisition for various purposes, like for laying on the railway lines, for construction of the roads, bridges, and various other purposes, even for the welfare of the people, like that of the construction of the water bodies, ponds, etc. So if such kind of land acquisition have to be done, then there are certain rules and regulations that should be followed in the region where the Santhal Pargana Tenancy Act is in function. So what are those? Here, the landlord of the village who is desirous of acquiring the holding or part of the holding of any rayat of the village for any reasonable and sufficient purpose having relation to good of the holding as well as village or the state will have to follow certain rules and regulations. So here, first of all, what are the circumstances under which he can do the land acquisition? So here, the welfare of the people, that is the rayats, and good of their holding, like the increase in the harvest through provisioning of the irrigation facilities and the other things, welfare of the village also, like the construction of common use roads, thereafter various other community also, whatever it is, as well as the state, right? So here, for these purposes he can do the land acquisition, as well as for the erection of the buildings. So for the erection of the government buildings or such kind of things, the land acquisition can be done. For any religious, educational or charitable purpose, so for these purposes also, like religious purpose, educational purpose, like the construction of Jahir Than or allocation of land for Jahir Than, construction of temple, for such kind of thing, the land can be acquired by the landlord, as well as educational purpose, like the construction of the schools, colleges, etc., or the charitable purpose, like the construction of charitable hospital or grazing land, whatever it is, right? Or for mining and manufacture, for this purpose, like these activities will be related to the government activities. So here, if the government wants to start any of the mines, if some kind of mineral resources are available in that region, then also the land acquisition can be done, and for that purpose also the landlord can do the land acquisition. Even today, wherever like the coal mines, iron ore mines, or the construction of railways or whatever it is going on, then nowadays the whole landlordship, the jamindari system has been abolished, and now the landlord, in that sense, if you go on to consider a jamindar or a landlord, then the CEO of your block is your landlord, and the land acquisition work is allocated to that person, although the supervision is being done by the DLAO, District Land Acquisition Officer, right? So he is there in the district headquarter. He supervises the land acquisition process that is going on or that is being done by all the CEOs who are under his supervision, under his control, right? So here, for the mining purpose or the manufacturing, like the erection or the construction or establishment of any of the industries, steel plant or whatever it is, for that matter also the land can be acquired. For the development of irrigation facilities, like construction of canals, dams, etc., also the land acquisition can be done, right? For effecting any agricultural or horticultural improvement, so like for the improvement of the agriculture in that region, the land can be acquired. Suppose that if the government wants to establish any of the research center for the agriculture purpose, or simply a demonstration center, then for that matter also the government can acquire the land, and that authority to acquire the land lies with the jamindar or the landlord. In the present day sense, it is lying with the CO, right? So here, or giving effect to any of the national policy of the government may apply to the deputy commissioner for the same. So for giving effect to any of the national policy, suppose that nowadays the construction of the roads are going on at an aggressive pace under the Bharatmala project, the new expressways, greenfield expressways are being constructed. So for those matter also the land is being acquired, and for that matter again the land acquisition is being done by the jamindar or the landlord, that is the CO, right? And here again it is being done to give effect to the national policies to improve the transport and communication system of the nation. And for all these purposes, if the landlord wants to do the land acquisition, then he have to take the permission from the deputy commissioner, the DC. He will have to apply to the DC for the same, and after getting the permission from the deputy commissioner, then only he will start the land acquisition process, right? And the deputy commissioner may, after due inquiry, right, in response to a valid application, sanction initiation of the acquisition of the proceedings, right? So here, after inquiring the purpose, like if some village upliftment or the improvement program is there, then the DC will analyze that whether the purpose is good for the common people, or if there is a national plan, then it doesn't matter, the inquiry is not that much needed, because it is a top down approach. The central authority itself is saying that you have to do the land acquisition. So simply here the DC will pass an order that start the land acquisition process. This is the route map, this is the regions in which you have to do the land acquisition, and accordingly the land acquisition will start, right? Now, on the passing of an order for the acquisition, the DC shall, after issuing notice to the riots, decide the claims and objections in respect of compensation. So, in many of the region, you may have witnessed that many of the farmers go on to protest that the compensation that is being given by the government is not adequate, and the reallocation process is not adequate. So the people go on to do the protest that increase the compensation for the land, the price per acre whatever is being provided by the government is not adequate. So in such cases the commissioner will will request the riots that they can forward a claim or the objection with respect to the compensation, that this compensation is insufficient for our reallocation, or the amount of land which we will go on to purchase in any other region for the purpose of farming is not sufficient, and we will not get the same amount of land. So many of the claims can be forwarded to the DC for that matter. And after such objections, after reviewing such objections, the DC can pass such order which he thinks fits, right? So the Rayat whose land is so acquired shall be entitled to receive a proportionate reduction in the rent in addition to the compensation. So suppose that a person was having a land of 1 acre, and from here on one side the Bharatmala project passes. So this much of land is acquired by the government for the development of new road project. So in such case, suppose that out of 1 acre of land, he loses his 1/4 of his acre. So in the same proportion, his land rent will also be reduced. So the government will order that this much of land rent will not be collected from such Rayat who has already lost 1/4 of his Raiti land due to the land acquisition process. So this is again a provision. And here, if the land so acquired is not utilized for the purpose for which it was required, within 5 years of taking the position, the DC may pass an order to restore the land back to the Rayat. So many of the times what happens, the project gets delayed. Many of the government projects gets delayed. But here again there is a provision that if even some amount of work has been initiated within 5 years, then that land will not be reinstated back to the Rayat. However, it will remain with the government. And nowadays the government of Jharkhand or even many of the state governments have passed various other land related laws, in which there is a provision that if the government had acquired any of the land for the development of industrial area or such kind of thing, and it has not been utilized for the development of industrial area, then such land are being allocated to land bank in the district, and later on such lands are being allocated to some other purposes for the development or industrialization or whatever it is. But here there was provision in SPT that within 5 years you have to start the project for which the land had been acquired, and if it is not being utilized for such purpose, then after the expiry of 5-year time period, the Rayat will get back the land. The land should be reinstated back to the Rayat if it is not being utilized for the said purpose. अगर आपने रोड बनाने के लिए जमीन ली थी, 5 साल के अंदर रोड का काम नहीं चालू हुआ, तो वो जमीन वापस रैयत को दे दी जाएगी, राइट. नाउ नेक्स्ट इज here, this is our books which have been already published for UPSC in both the English medium and the Hindi medium, as well as the JPSC books are also available in both Hindi and English medium. So if you want to purchase these books or you want to get these books, then you can go on to order it on our website, our app, as well as you will get these books from Amazon also, as well as if you want directly to contact us, then you can go on to contact us from the contact details. Those are provided in the description box below. So this was a short information to ease out your path of preparation so that you can get the holistic material, holistically compiled material at a one point, right? Now, next is chapter 7. So here chapter 7 says that certain judicial procedures should be followed while adjudicating any of the issue. Those are under the Santhal Pargana Tenancy Act. So here section 54 says that the state government may make rules in respect of the matters for which the provisions is not made under this act. So this was a kind of delegated legislation where this open-ended thing was left behind, that later on the state government, according to the situation, according to the need of the time, can formulate various rules and regulations, may pass the acts or the related things if they think it fit. Then they can use this section, power under this section that is given to the state government under section 54, that the state government can make the rules with respect to the matters which have not been discussed or which have not been delineated under this act, which have been left behind, unaddressed issues, right? Next is, until such rules are made and subject to those rules when made, the cases shall be dealt with under those rules and provisions existing under the previous acts. So whatever the acts which are in existence within the state, within the region, will apply till date when the government, state government in fact, passes the new acts, rules or the regulation, notifies them in the Gazette of the state. Till then, the previous rules which are already in existence will be utilized to adjudicate the issues. Section 55 says that where a landlord has instituted a suit against a Rayyat for the recovery of any rent of his holding. So suppose that there was some kind of due and the Rayyat was unable to pay, and after lapse of certain time period the Rayyat is still unable to pay the land rent, and the landlord thinks that now onwards he is not going to pay my rent, then in such case the Rayyat may file a suit, the Rayyat may file a case, not the Rayyat but the landlord may file a suit, landlord may file a case against the Rayyat for the recovery of the rent. However, the landlord shall not institute another suit against him for the recovery of the rent of that holding until after 6 months from the date of institution of the previous suit. So suppose that any of the suit was filed against a Rayyat for the recovery of land rent by the landlord on January 1st of January 2023. So till the time of 1st of July 2023, he cannot file a suit for the same purpose for the recovery of land rent from the Rayyat. So there should be a cool off period of at least 6 months, 180 days before filing another suit for the recovery of the rent from the Rayyat by the landlord. So these are the provisions. Now the eviction. So suppose that if a Rayyat have to be evicted from his holding, so under what circumstances such kind of things can be done? No person shall be evicted from the agricultural land except by the order of the DC. So the landlord or the Mool Rayyat or the Jamindar or whatever it is, the village headmen who are available and who are having the right to collect the land rent, they cannot evict any of the Rayyat from their holding by their own. If such kind of action has to be taken, then they have to file a suit, have to file a case in the court of DC, and after the order is being passed by the DC that this Rayyat had missed the payment or some certain kind of breach of agreement or breach of the traditional way of land utilization or whatever be the circumstances under which he can be evicted, then under such circumstances the DC may pass the order that you can evict this Rayyat from his holding, and only after that the Rayyat can be evicted. And where a Rayyat is evicted from his entire holding, the DC may at his own discretion permit him to remain in possession of his dwelling house and may decide the rent payable for the same. So if the Rayyat is being evicted from his complete holding, but still the DC may permit that you can possess your हाउस, योर ड्वेलिंग, जहां पर रह रहे हैं उस घर को आप अपने साथ रख सकते हैं, उसमें रह सकते हैं, एंड द रिड्यूस्ड रेंट दैट मे बी एप्लीकेबल फॉर दैट पर्टिकुलर होल्डिंग ऑन विच द ड्वेलिंग एग्जिस्ट, जिस पर घर बना हुआ है उसका लगान तय कर दिया जाएगा डीसी के द्वारा. ठीक है. सो इन सच सर्कमस्टांसेस द डीसी, because you cannot leave a person homeless, simple ethics, simple humanity, right? So the government have to follow the humanity also, right? Now appeals, that is under section 57. So except or otherwise provided in this act, the appeal may be filed against any order passed under this act. So if any of the order is being passed by the SDO, by the CEO, or by the additional collector, or whatever may be the case, then against such orders the appeals can be filed to his higher authorities. In general, it is a common sense, it is a common rule of law that the appeal against any order may be filed by any person to the authority which is higher to the authority who had given the verdict in the earlier suit, right? So this is the simple rule. कभी भी बड़े अधिकारी के पास ही जाना है, right? So with the SDO vested with the powers of DC on with behalf, where the order was made by the deputy collector exercising the power of the DC, right? So if a deputy collector is having the power to evict a person, but he had delegated his power to the SDO, subdivisional officer, and the subdivisional officer had given any order for the eviction of the Rayyat, then in such cases the appeal for such cases will be filed to the DC, the deputy collector, against the order of the SDO, right? And the DC shall have the power to order any such appeal to be transferred to his own file or to the file of the deputy collector, right? So if by his own motion the DC thinks that this order was not perfect, this order was not according to the law, or something like the malified intention was there. So in such cases the DC may order that this case should be brought to me. He will take that case on his own file, right? And with the DC, where the order was made by the SDO exercising the power of the DC, this is the same thing with the commissioner, where the order was made by the DC or the additional deputy commissioner. So wherever the additional deputy commissioner or collector or the DC, that is the deputy commissioner or the collector, have passed any law, any order which is, so it is thought by the Rayyat that was not good and not in his favor, and he thinks that I should go for the appeal, then in such cases he will go straight away to the commissioner, Ayukt ke paas chale jayenge, right, to appeal against the such order. And with the tribunal appointed by the state government where the order was made by the commissioner, and even the commissioner gives the verdict against such order that was not in favor of any of the party, and any of the party, whether the landlord, the Rayyat, or whatever the case may be, thinks that now he should appeal against this verdict, against this decree, to the higher authority, then he may go to the tribunal, straight tribunal, right, that tribunal for the land related issues that has been appointed by the state government, right? So this is the hierarchy of the whole appellate process under the SPT Act, right? Now the second appeal, this is the process, this was the process of the first appeal. Where does the second appeal lies? That is given under section 58. So subject to the provisions of section 59 concerning the revision, an appellate order shall be final in all the cases where the decision of the lower court is affirmed. So suppose that the order of the SDO was challenged in the court of the DC, and the same order had been passed, same verdict was given by the DC again what was given by the SDO, which means that the order has been upheld, the SDO order has been upheld. So in such cases no second appeal will lie. Two consecutive authorities if give the same verdict in any case, then there will be no possibility of second appeal. Only when the second appeal will lie when the case, in the case the verdict has been overturned, right? So here the additional deputy collector or the DC has varied the decision of the lower court. In such a case the appeal may be filed, the second appeal may be filed. So suppose that SDO gave an order, it was appealed in the ADC, additional deputy collector or DC court, and they changed the verdict. This was in favor of Rayyat, and this goes into the favor of landlord. Then again the Rayyat may go on to file a case to the commissioner, higher authority, right? So he will go on to challenge this order in the court of commissioner. But in case if the SDO and the DC both give the same verdict, in case like in favor of the Rayyat, then the landlord cannot challenge it in the court of commissioner, right? So here with the DC where the appellate order was made by the SDO vested with the appellate power, with the commissioner where the appellate order was made by the DC or the additional collector. So same here the hierarchy will go on, right? So this is the procedure of second appeal. Now the revision, that is under section 59. So suppose that while compiling the records of rights or any such kind of thing, if there was some mistake, clerical mistake or whatever it is had been committed, so you have to revise the record of rights. So in such circumstances what will happen? The commissioner or the DC may on his own motion or otherwise call for the record of a case decided by the court under his control in which an appeal does not lie. So here the revision, first revision will be related to the cases So suppose that the SDO court and the DC court gave the same verdict, and now the second appeal does not lies. But if the commissioner thinks that I have to look after such kind of issues which were not being heard under the second appellate authority, and he thinks that this has the certain circumstances which he should look after, then in such cases he may bring the case, he may call for the case file, and he may do some kind of revision. However, the commissioner shall not pass such an order on the application by a party until the DC or the additional deputy commissioner has heard the matter in revision or appeal and passed an order. So none of the steps of the hierarchy can be eliminated. You have to follow the proper channel of the hierarchy. First of all, you have to go to the SDO, thereafter the ADC or DC, and then only the commissioner. And even the commissioner cannot say that lived behind the additional collector or the collector, and straight away give the file to me from the SDO office and I will look after the issue. So such kind of things cannot be done. The DC may by order in writing empower any subdivisional officer under his control to exercise the power of conferred on the deputy commissioner by subsection 1 concerning all or any of the decisions of the court or the deputy collector not in charge of the subdivision under the control of the DC. So here it says that subsection 2 says that clearly that the DC can delegate his power to any of the SDO, his subordinate SDO, to exercise the power of DC, and to those SDOs who are under his control, under his supervision. Like many of the cases are being heard by the additional collector or the SDO, and their verdict, their decision also have the same effect of that, the kind of effect that lies with the order of the DC, right? Now here review section 60. So the commissioner may for sufficient reason to be recorded in writing review any order that has been passed by himself or a predecessor in the exercise of any power conferred under this act. So suppose that earlier any of the order was passed by the same DC or any other DC, and he thinks that there is a review that is needed for that particular order, then in such cases the DC may go on to review the issue on his own motion, of which were given the verdict which were given by himself, or for those orders or verdicts which were given by the earlier deputy commissioner. An officer subordinate to the commissioner shall not review any order made by him or by a predecessor except to correct a clerical error or other errors being a result of an oversight without previously obtaining the permission. So the review power lies only with the commissioner and not by the subordinate officers. So all the subordinate officers who are subordinate to commissioner cannot exercise the power of review. Only for the clerical errors they can use the power of review, and for that matter again they have to get the permission of the commissioner, that in the record of rights such kind of clerical errors were there, such kind of things were not correctly mentioned and we have to correct it. So for that matter, first of all they will get the permission from the commissioner, and then only they can correct the clerical mistakes. So such kind of review can be done only with the prior permission of the commissioner, right? Next is the permission of the deputy commissioner in the case of the deputy collector or the SDO is needed. So if the SDO or the deputy collector wants to do any kind of the correction, then deputy commissioner will give them permission to do such kind of corrections, right? And the permission from the commissioner in case of deputy commissioner or additional collector. So the immediate higher authority have the authority to give the correction of order for the correction of clerical mistakes, right? Now here, section 61, it says that an order passed by the DC shall not be varied on appeal or revision on account of any irregularity of procedure unless the irregularity has occasioned or is likely to occasion a failure of justice. So suppose that some of the person goes on to claim that the proper procedure was not followed, proper channel was not followed, various kind of allegations are made by various people. If they lose the case, so in such cases the revision will not be done, the appeal will not be that of effect that may vary or revise the verdict until and unless that will cause the failure of justice. Such kind of, suppose that some of the evidences were not filed, then in such cases the case may be reheard, re-looked, and the revision may be done. Otherwise, other circumstances which are not going to vary the final verdict of the case and that is not going to lead to the failure of justice, then such kind of revision, such kind of appeals will not be entertained. Section 62, it says that in the performance of his duties and exercise of his power, the DC shall be subjected to the general direction and control of the commissioner. So oversight power for the DC will lie with the commissioner. Obviously बात है, hierarchy follow होगी. Additional deputy collector, subdivisional officers and the deputy collector shall be subject to the direction of the deputy commissioner. तो डीसी के पास बाकी के नीचे सबऑर्डिनेट ऑफिसर्स की ओवरसाइट की और सुपरविजन की पावर रहती है. एवरीबॉडी नोज दैट इट इज द जनरल रूल, राइट. Next is section 63. Here it says that limitation to the suits. So there are certain limitation on filing the suits, filing the cases. So here it says that no suit shall be entertained in any court to modify or set aside either directly or indirectly any order of the DC in any application which is cognizable by the DC under this act, and every such order shall subject to the provisions of this act relating to the appeal and revision may be final, right? So no court, no civil court can interfere in the procedure of looking after the cases related to the SPT Act that are being heard in the court of the DC, right? And here the appeal and the other revisions and the other things cannot be done by the civil court which are subject to the provisions of this act and relating to the appeal and the revision, and that will be final. That are which are the cases, those are cognizable by the DC court. Here the verdict related to such cases will be final by the DC court itself. Here the civil court cannot interfere, right? तो लैंड रिलेटेड इश्यूज में जैसे होता है ना, सीधा बोलते हैं डीसी कोर्ट चले जाइए, एसडीओ कोर्ट चले जाइए, तो ये यही मामला है, राइट? So here we finish off chapter 6 and 7. Thank you very much for watching the video, and if you have watched the video till this point, then go on to subscribe the channel and press the bell icon to get notified whenever we upload new videos. You can also follow us on our Facebook and Instagram handle. This is our Telegram channel. You can also download our app from the Google Play Store, available on the Google Play Store. The link for the app is provided in the description box below, as well as you can also visit our website for various courses, for various free study materials, free tests and the other things. So here we finish off the discussion. Get back to the next and the last part of the SPT Act. Later on we will start the various other things like the geography of Jharkhand and the other topics. Thank you very much and have a nice day.